We're on. Okay, hello, welcome everybody. This is Roger Royce. I'm a partner with the law firm of Haynes Boone, an AmLaw 100 law firm. I work out of the Palo Alto office in emerging growth and venture capital. And this is the 10,000 Startups podcast, where every week we bring you a new interview and discussion with a lawyer on an area of law that touches startups. And this week, we're going to be talking about a really huge issue for startups, one of the biggest ones maybe, which is just labor and employment. And we have with us today Tamara Devitt. She's a partner with Haynes Boone in our Orange County and Northern California offices. She represents employers in all aspects of labor and employment law, discrimination, harassment, wrongful termination, and unfair business practices. That's a big one in California. Wage and hour claims, probably even a bigger one, including class actions and complex litigation. So Tamara, first of all, thank you for being here, because this is going to be really important information we're going to share today.
Thanks for having me, Roger.
Well, let's kind of start off. I mean, so I do, emerging growth and venture capital. I form companies, and kind of the number one biggest issue, I think, for startups has to be misclassification, because especially here in California, where it feels like almost everybody's an employee, and if you get that wrong, it can be just disastrous. So I guess, first of all, let's kind of go to the fundamental issue. What is the difference between an employee and an independent contractor?
That's a big question, and more complicated now given recent changes, especially in California law, but even trends at the federal level. So an employee would be a W-2 individual providing services or working for a company, whereas a contractor is generally considered someone who has their own business, but contracts with a company to provide specific limited services. And traditionally, the big issue or fundamental issue as to whether an individual was an employee or an independent contractor it's a multi-factor test under multiple different avenues, but it had to do with the right to control, or the right to control. So if a company had to right to the control what the individual was doing, that was generally an employee. Whereas if the company didn't, this contractor kind of had the right to do what they wanted to do when they wanted to do it, as long as they delivered a product, that was considered not to be an employee but a contractor. The law's gotten increasingly strict on what that test is, especially in California with the passage of AB 5. There have been a lot of challenges to that. Most of them have been unsuccessful. But now the rule is essentially, there's a presumption that an individual providing any type of service to a company is an employee and not a contractor. And it's up to the company or the putative employer to prove that the individual providing services is in fact a contractor.
Okay, you cut out a little bit, so I just want to reiterate. It's AB. What's the name of that statute? AB 5.
AB 5. Right?
Yeah, AB 5, which is now codified in our labor code. And I think what you said is the presumption that a service provider is going to be an employee, so then you have to prove that you're not. And exactly. you said earlier it was just a control test, right? So in other words, if somebody controlled the manner or means of how you're performing the services, that was the basic test. And now it's a little different under our new California rule, right?
It is a little different. To be fair, the test historically has been a multi-factor test. So even though the biggest factor was the right to control, there still were a lot of different factors you had to look at in order to kind of figure it out. Now, I think it's not necessarily simpler, but it's an exception to be a contractor as opposed to an employee, because that's the presumption under the new law. And there are defined exceptions. The exceptions are frankly more complicated than the rule, but it makes it really difficult for a company just to have any kind of contractor I think the best example I can come up with is, somebody who's a gardener and tending to the bushes in front of your office building. That's going to be a contractor, whereas anybody who provides any type of service that connects with the business being provided, what the business services are provided, is likely to be found an employee. And so it's not easy to get around that, even if you have the best contract in the world.
Yeah, and of course there are exceptions to it, but there are difficult exceptions to difficult, complex, and technical, right?
And very nuanced, right? So there's certain industry exceptions, like physicians, because there's a whole set of rules associated with that. But they don't apply to kind of every type of company and every type of industry.
So what if I'm an out-of-state company and I hire someone in California? Am I going to be subject to these rules?
Probably. So for purposes of the labor code under California law, if you have just one employee in California, you have to comply with California law. Just one's enough. There's a slightly higher threshold for our anti-discrimination statutes. So under California's Fair Employment and Housing Act, you have to have 5 employees, but the way the laws are interpreted, for the most part, in many cases, it counts employees outside of California as well. So if you have anybody in California, you're going to be subject to California law for all intents and purposes.
Is this true? What if I say that make all my employees sign something that says we're going to agree that Texas law applies or Minnesota law?
So California's addressed that in Labor Code section 925, I think, which prohibits that type of agreement. Essentially, it allows the individual to void that agreement, and if an employer would require it and an employee chooses to void it, they can actually recover their attorney's fees in doing so. There's a couple of exceptions if somebody's represented in the context of a negotiation, but you can't present an employee who's unrepresented with a paper saying you agree to be bound by Texas law if they're in California.
Wow, so that could be very punitive. I could see a California court calling that an unfair trade practice as well.
That's right.
Like that. Yeah.
That's right. It's easy now because there's a statute.
Yeah. So, the second, well, before we leave the misclassification, because this is just so important, like I'll often tell people, and I've mentioned it in my book, if you don't think this is a big issue, just go Google HomeJoy. Here was a company that was like the Uber for house cleaners, that classified all their housekeepers as independent contractors and not employees. And that company suffered a significant class action lawsuit, which we're going to talk about. And they went under after raising $40 million of venture capital. And the CEO later said if it hadn't been for that class action lawsuit, he thinks they would have been successful. So tell me, what is this thing that we should, because I know the employers are out there thinking, well, okay, I messed up with one employee, or I messed up, but only one employee complained about it. What's the big deal? I'll pay them off and just go on my merry way. But we got something here called Private Attorney General's Act, don't we? So how does that all work, Tamara?
Sure. So if an individual, if somebody's claiming they were misclassified as a contractor when they should have been an employee, and it's a one-off situation, then yeah, maybe you're okay in trying to negotiate that. There's going to be tax consequences as well as potential unpaid wages under the labor code. But the bigger, broader concern would be if your business model is based on an assumption that the individual is a contractor, like the HomeJoy connection or cake company you're talking about in that situation. So the Private Attorney General's Act allows an individual to stand in the place of the state and sue for civil penalties that were previously only available to a state. So essentially, California allows someone to act as a private attorney general and sue not only on behalf of themselves, but on behalf of all aggrieved employees, meaning anybody in that same situation. And so what that means is they can sue for the underlying wages that they're claiming that they weren't paid. But on top of that, the PAGA is what it's the shortened version of it, allows the individual and the aggrieved employees to recover a per pay period penalty amount. It's either $100 or $200 per pay period for any violation of the labor code, essentially. So that really adds up, and it's again on top of the wage claim itself or the other violations. And then, of course, they would recover, if they're successful, attorney's fees. So that's every, companies large and small are being sued every day for these private attorney general act actions.
How bad can that be for a company? Is this the kind of problem that can take a company down, especially a startup company, or is it one that they can maybe just kind of close one eye and look the other way and ignore and hope it never does?
It's not something to be ignored. That the plaintiffs bar in California is very active. They're very aware of how these cases work and how difficult it is to defend against them. And so, on top of all these penalties adding up very quickly, and so the risk of losing is very significant. Just the repeat players, right? So companies get sued repeatedly for these types of violations. There's a 1-year statute of limitations, but so that means you just see more lawsuits.
Got you. And then the nature of the lawsuit, we should maybe talk a little bit about the other aspects of California law on this that are really, I think, kind of troublesome. Is that to me, as not an employment lawyer looking at it, it seems to be such a Byzantine system. These meal breaks, rest breaks, what's an exempt employee, what's not, who's subject to these rules, overtime rules. It seems like really difficult, even for a large employer with their own in-house HR department to comply with. God, what chance does a startup have? But let's kind of start with the fundamental thing is, like, I hear people talk about exempt and non-exempt employees. And I know that has significance. So what does that mean, and why do we care?
Sure, and we do see this a lot with startups, Roger, where the company basically assumes that everyone is exempt. So they pay them a salary and they don't keep track of their work hours. They don't really follow some of these strict rules like meal and rest periods and overtime. And it turns out they're not exempt. So it's a really good question and something to pay attention to. There are, under federal law and state law, there are 2 parts to the exemption test. The first part is the salary basis test. So an individual has to make a certain amount of money, that threshold amount of money, to qualify as exempt. There's a weekly amount under federal law, but the state law for California is twice minimum wage. So minimum wage, I think, is currently $15.50 an hour. So it works out to be something north of $60,000 an individual has to be paid on an annual basis to be exempt. Then on top of that, you have the duties test, or in addition to that, you have the duties test, which requires an individual to be exercising independent judgment and discretion in various ways. So an executive type individual would be likely be exempt, but someone who's say an accountant may or may not be. It depends on what they're doing exactly and what their role is. Not only that, under California law, have to be engaged in exempt duties more than 50% of the time. So there's actually a quantitative component to it, unlike the federal test, which just requires the employee to have as his or her primary duty these exempt type duties. So it's fact dependent and complicated, but a lot of companies miss those nuances when they just kind of assume anybody who's being paid, $60,000 or $70,000 is exempt.
Mm-hmm. Yeah, so it's very sounds like it's a fairly complex analysis. That's more than just how much you're being paid. It's also what you're doing. You know, speaking of exemptions, we often, well, I would say we always rely pretty heavily on, I guess, what we would call the founder's exemption from all this. Because founders, we would prefer than not pay them a salary, because it doesn't make sense to have the money go into the company on a, non-deductible basis, then come right back out, on a taxable basis, subject to employment taxes, et cetera. And I think people might feel a little bit fast and loose with that one. So I guess, first of all, what is the exemption that founders get from being subject to these rules?
So if really the exemption is for an owner. So if you're an owner of the business, then you wouldn't be considered an employee. And so you couldn't, recover any type of wage or damage under the labor code. What we often see is, somebody with just some equity. Companies think somebody with just some equity is enough to qualify for that type of exemption, which if an individual is an employee and a W-2 employee, then they're not going to be qualifying for any type of owner exemption. They're going to be covered as an employee. And that means they have to be paid minimum wage at least, and treated as non-exempt, meaning they have to have meal breaks and rest breaks and keep track of their
Can I
time.
pause on that for just a second? Sorry to interrupt,
Sure.
but this is important, because I tell people this: you got to pay a minimum wage, and they say, well, we gave them all the super valuable stock in our company. Does that work?
It doesn't work.
Okay.
It doesn't work. Nice try, but it doesn't work, because it doesn't satisfy what's required for employers to pay employees under state law and federal law.
It's got to be cash, and it's got to be current, right?
That's right. Exactly right.
Okay. All right. I interrupted you. I'm sorry.
Oh no, that's all right. What I was saying is, if an individual is non-exempt, then there's a whole host of requirements and obligations. You mentioned California's onerous statutory scheme when it comes to wage and hour issues, and this is where it comes into play. Employees have to keep time records. They have to be paid overtime for work over 8 hours in a day. They have to be provided with meal breaks, and that rule is very specific. They have to be provided with 30 minutes of duty-free time for every 5 hours of work. And if they aren't, there's a monetary penalty associated with that. People get it wrong all the time, and employees can't just voluntarily decide they're not going to take a meal break. They can technically under the statute, but more often than not, that gets spun later as the employer preventing an employee from taking a break. So there are significant risks if an employer chooses to ignore some of those statutory obligations, and there are a lot of them. So it's not easy.
Yeah, and just anecdotally, I've seen it happen where you get an employee that's gonna, like, a non-exempt employee is going to do their employer a favor and start doing work on their own time, and not tell the employer. And so they're doing overtime they're not getting paid for. They're not taking breaks, etc. And then it becomes a big problem, right?
We see that a lot. I think in the startup context, you have probably a smaller number of individuals who are working to get everything going, right? And so everybody's kind of working all the time, without necessarily thinking of the consequences, and that's what's really difficult.
Well, this work from home and remote work must be a huge problem in this area, because how do you police meal breaks and rest breaks then?
That's a great question. It is difficult. I think the best companies can do is make sure that their policies are disseminated, that they have a policy, number one, that it's compliant, that it's sent to employees, that they have proof it was received by the employee, and then that they're auditing or monitoring their time records to ensure that the practice is matching up with what the policy requires, and then taking action if the employee is choosing not to.
Yeah. And then the other thing I want to pause on this, because it's not the first thing you might think of, but it is really significant, is this attorney fee shifting provision. So let's say we've got an employee and they claim I underpaid them by $10, and I'm going to stand on principle and say, no, I didn't. And they sue me, and it turns out I do owe them $10, but I owe them a lot more than that, don't I?
Well, the statute, all the employment related statutes in California and under federal law, they're designed to give an employee a chance, right? To give them a chance to sue. And so because of that, all of these types of statutes have really one way attorney fee provisions. So if the employee wins, they're able to cover attorney's fees. Whereas if the employer wins, they're often not able to recover attorney's fees.
Yeah, and there are some, fairly, I think, well-known cases in California where the attorney's fees were more than the recovery. In some cases, because the lawyers who prosecute these cases, they have no incentive not to go ahead and aggressively pursue them. So let me ask you, I want to be sensitive to your time here, but are there any other than what we've talked about, are there any other really significant traps that you see startups fall into when it comes to employment and labor?
Yes, I think it's really important, especially at the startup phase, that companies are looking at their confidential information and their proprietary information and their trade secrets, really all their IP, but making sure that there are agreements in place with employees to protect that information. State and federal law would give a company who has a departing employee some opportunity to sue that employee if they're taking their stuff. But you want a rock solid agreement in place, one to just deter an individual from taking your confidential information. But also if you have to get to litigation to get it back or to stop somebody from doing something wrong, that you have that kind of behind you. So a lot of companies, pull something off the internet, which is dangerous to begin with, especially in California, where we have restrictions on how you can restrict people from kind of moving around, right? So I think most people understand in California that you cannot have, in most circumstances, a non-compete or any type of restriction on employee mobility. But there are things you can have in California. So you want to make sure you have an agreement that maximizes the protection for confidential information, trade secret information, and proprietary information.
Yeah, and of course, on that point, there's some stuff that an employer just can't do, right? For example, the labor code provision that provides that if someone does something on their own time and with their own facilities, and it doesn't relate to their employee's business, and it doesn't arise out of work they've done for their employer, then the employer can't take that away from them, right?
Exactly right. Exactly right. So California has nuanced protections for the employee, and the company has to work with those in its agreement.
Right. Okay, great. Okay. I want to thank you for being here today. Like I say, the employment law issues and the labor law issues represent maybe the biggest potential liability that I think startup companies have on formation, and even and after they're formed, and even after they get financed sometimes, as we've seen in the case law. So this is really important, and every employer needs to pay attention to it. In the book, I use the example where I reference Reid Hoffman's podcast, Masters of Scale, where he said in startup land, you're constantly putting out fires, and you have to know which fires to let burn and which fires to put out. And I tell people that you have to look at employment, especially misclassification, as a California forest fire. You got to deal with that one. You cannot let that one burn. You have to be sensitive to that. And after today's discussion with you, I think we can all see why that these are really big issues. So again, this is Roger Royce, 10,000 Startups. We've been talking to Tamara Devitt from Haynes Boone, Orange County. I want to thank you for being here, Tamara. And if people want to get a hold of you, I'm sure they can find you on the Haynes Boone website, right?
Absolutely. Thanks, Roger.
All right. Thank you.